Dumelang bana ba ntate Modimo hoseng wa letsatsi. Lebitso la ka ke nna Lemohang. Ke tlotla ke le balla ditaba ke ipapisitse le hore na ho etsahetse jwang Nyeoe ya kopo ya beili ya Dr. Lipholo letsatsing la maobane. Dr. Lipholo o hlolwa ke Nyeoe letsatsing la maobane. Dr. Lipholo o hlotswe ke Nyeoe lekgotleng la Maseterata Maseru moo a neng a re lekgotla le mo lokolle ka ha a se a hlotse matsatsi a fetang 60 tjhankaneng. Nyeoe ena e hlakwetswe lethathamong la dinyewe tsa lekgotla leo ka mora hore botjhutjhisi bo hlalose ha e se e le ka hara lethathamo la dinyewe lekgotleng le phahameng. Ha ke tsebe na ho ya ka puo ya makgotleng ha ho thwe e hlakwetswe ho bolelang. Nyeoe e salletseng morao ho tseo a qositsweng ke ya teko ya ho diela mmuso eo lekgotla la Maseterata le itseng a itlalehe lekgotleng moo ka la 20 kgweding e hodimo e leng ka di-20. Maseterata Matankiso Nthunya le ha e le hore o itlhalositse a sa kgotsofalla tsela eo ditaba tsena di tshwerweng ka teng, o itse ho latela molao ha ho seo a ka se etsang, mme jwale e tla lokela ho fetela lekgotleng le phahameng. O supile hore o na le maikutlo a mangata haholo mabapi le tsela eo botjhutjhisi bo tshwereng ditaba tsena ka teng. Dr. Lipholo o tla tswa ntse a le setsing sa tlhabollo ya batshwaruwa ha ntse a emetse Nyeoe ena e tswele pele. Botjhutjhisi bo itse bo se bo bokelletse bopaki Nyeoeng ya ho nyenyefatsa lelapa la botlotlehi le ya ho hlohlella moferefere. Ha e le ya teko ya ho dia mmuso yona e ntse e le dipatlisisong. Ke ka tsela eo taba ena e ripotuweng ka teng. Jwale batho ba fane ka maikutlo a bona empa pele re a maikutlong ha re mameleng hore na di kgakgathuwe jwang ditaba tsena Nyeoeng ena letsatsing la maobane.
I think I was a bit taken aback by the prosecution's attitude. Your worship, following consultations, our attitude is this one. The Crown is seeking a postponement on the grounds that this court does not have jurisdiction to entertain this matter. And they predicate their position on the fact that the accused has been indicted at the High Court. And our position is that, in terms of the law, the remand court, which is this court, has jurisdiction to entertain applications in terms of the Speedy Court Trials Act. So the only jurisdictional fact, as far as the court is concerned, should be that there's an accused person who has been remanded in custody, and that the period of incarceration should exceed 60 days. Now, those are on that day, which is today, is whether there are exceptional circumstances that warrant the detention beyond the 60 days. So our position is that this court absolutely does have jurisdiction, Your Worship. So as a substantive point, that's how we would like to deal with it. But we'll also, Your Worship, it's important that we also project that our instructions are that this indictment has been done out of now what could be said which we call now a deliberate stratagem by the prosecution to delay this case. It's very heavy-handed, Your Worship, to say so, but we will demonstrate how and why we have elected to use that language. Why we are saying this is a deliberate, it's nothing but a deliberate attempt by the prosecution to delay the application for release. And now we want to demonstrate why. Firstly, the very fact that we were served with it while we were in court. Literally, we were served with it while we were sitting in court. A clear ambush strategy. A clear ambush strategy. Designed precisely to postpone. If Your Worship looks at the indictment itself, it was signed on the 7th of November. It says so ex facie on the last page. It's on the 7th. Today is the 11th. They literally picked not just the 11th day, but the 11th hour. Quite literally. And there's no justification whatsoever why that happened. None. One other colleague was content with, oh well, I gave Mr. Supi a call. But that's not enough. So that speaks, Your Worship, to the strategy. But it doesn't end there. This is just what happened before, Your Worship. There's more where we came from. There's more. Yes. So I received the call at around 1 o'clock or 12 o'clock at the very most. I want to be generous to my learned colleague. I want to be generous and say 12. But still not enough. But like we said, Your Worship, this was not the first time this happened. And I want to now bring the court's attention with what will appear on the record itself. The application, Your Worship, for release, this application, was served on the Crown on the 16th of September. But they knew before then that we were going to serve them. But for the record, they were served on the 16th September. And the matter was to proceed on the 26th of September. And on the 26th, Your Worship, when the matter was set to proceed, just like today, the prosecution and the Crown rose to move an application for postponement. Quite literally. I think my learned colleague, Advocate Pansy, it was at the time. Now, that application was opposed and it was dismissed by the magistrate because it was baseless. And the magistrate saw that it was intended for nothing but to delay the proceedings. So it was dismissed. Now, the next step in the prosecution's stratagem was to ask for a lunch break. Well, it was granted. After lunch, very important, Your Worship, the prosecution came just like now. We were ready to proceed at 2:30. What did the Crown do? My learned colleagues, Mr. Fuma, present at that time, rose with an application for accuser. We were not even made aware of the recusal application in the morning. In the morning, postponement. When the postponement failed, oh, now it was recusal. And we submit that recusal application, again, was nothing but an attempt to delay and in doing so deny the accused his constitutional right to liberty. That was the only reason. The judgment was granted, or ruling was granted on the 7th, Your Worship. So on the 7th, His Worship delivered the much anticipated ruling. We're not going to the nitty-gritties, but what is important for today's case and for Your Worship to note is that His Worship Tamai made a finding that the application for recusal was absolutely baseless. That was a finding of the magistrate. Absolutely baseless. He said, despite the prosecution leading three witnesses. They couldn't establish a thread of evidence to establish the case. And at the end of the day, the magistrate came to a conclusion that this recusal application was nothing but an attempt to delay. This is why he said, despite no grounds, I recuse myself. Come on, swear high. The crown is they are going to take this matter on appeal and have further grounds to delay. Because that was the only reason for postponement there. By Fuman into my Batlam from Piga 11 and 7, they got it. Despite principle defying him, he stepped aside. We were supposed to proceed therefore today. The finding of the magistrate was this: I recuse myself. That was the finding of the magistrate. And it went further to say, set this matter down immediately. Now, on the 7th, now we are coming into the last stages of this delay tactics. The 7th, the judgment is not in their favor, but it gives them what they want. Now they have to proceed. What do? Oh, conveniently now, we have this indictment in the High Court. Conveniently now, when everything else has failed, so that is the context within which, Your Worship, we submit that this indictment, not only does it lack in substance, but most unfortunately so, it is being made for malicious purposes. And the history speaks for itself. And Your Worship, just to speak to how unfortunate this indictment is, we have noted that the charges that are referred to the High Court are tribal here in the Magistrate Court. The charge of treason, that which could only be tried in the High Court. No, they left that one here at the Magistrate Court. You are not really in terms of the law. This one will be tried at the High Court, the treason charge. It's a High Court. This one that can be tried here. This one has been High Court. And again, that incoherence. Speaks to the malicious nature of and now Yes, and Your Worship, we're at a stage where at least we have made a point that in terms of the facts and the law, there are no exceptional circumstances why this accused person should continue to be incarcerated beyond the period prescribed by law. And ours today, Your Worship, is to demonstrate that the prosecution is not ready to proceed. And why do we say this, Your Worship? Firstly, is they are not ready to proceed. Why do we say this? They have not provided the defense with any witness statement. So from the 4th of July, remanded in custody up to today, the accused is not any more informed of what evidence there is against him. Still clueless. And yet the prosecution claims to be ready. How can we be ready to proceed? And the issue of statements, it's serious because the prosecution undertook, on the record, it will reflect, that they promised to provide witness statements on the 9th of September. Yes, they had promised, Your Worship. And this appears just so that when Your Worship reads the papers, it appears on paragraph 5.3 of our founding affidavit. 5.3. It says the record will reflect further that the prosecution had undertaken to provide witness statements by the 9th of September. They undertook. Paragraph 5.3, Your Worship, of the founding affidavit. So they, and it will also appear on the record of the appearance that preceded the 9th of September. That would be around the 6th or so. So it appears on the record that they promised to provide witness statement. Yet today, nothing whatsoever. So it's important. They are already failing to live up to their own undertakings. They have said, we have witness statements, complete. They even said, Your Worship, that they are ready to set a date. And of course, Your Worship, our law is very clear that an accused person is entitled to witness statement at the earliest convenience, not at the discretion of the DPP, certainly not. At the earliest convenience. And the law goes further to say the prosecution should avail to the defense all evidence in their possession as at when they have it. Even evidence that will help the accused. They actually even have that obligation. They have that is a constitutional obligation that the Crown owes to an accused person. And your worship will provide an authority for that case. It's the case that was argued by the late High Profile KC. Mulapo, Lepoko Mulao, my learned colleague came to my assistance. Tabazina, they have been argued. Give a full High Profile KC. They are here recorded. You cannot try a man without giving him statements. You cannot. We cannot set a date to submit the statement. And this continued position has already caused prejudice, and this is how. The Crown made an application to separate charges, and today they have made a decision to indict, to take certain charges to the High Court. Now, these decisions will prejudice the accused. They're prejudicial. In this manner, in practical terms. If he now has to contend with the possibility of separate trials, but that emanate from the same facts, it says that will cost him time and resources.
Your Worship, I'm trying to follow the submissions by my learned friend. Well, I actually not happy to interrupt the council while submitting. However, I feel obliged now to stand up to object at this stage. The terrain my learned friend is getting into, I think is not correct. Now, remember the separation of the charges has already been done, has already been granted by this honorable court long time ago. Now, for my learned friend to bring that up, says this court should review the decision that has already been made. While we thought my learned friend was arguing or addressing the court on whether this honorable court can proceed to hear the application for release on speed trial. So, when we engage in a matters that has already been ruled on, I think that is not proper, and we have to object, and we object, Your Worship, to that line of submission or argument.
But Your Worship, we are not making those submissions to ask the court to overturn that decision. We are simply saying to the court, while the accused person has been remanded in custody, developments have been happening in the case, which developments are prejudicial to him.
Okay.
Yes. And my colleague is not even saying that is not true. He's simply saying, no, don't tell the court about it. So we are not even asking the court to overturn. You have gotten it, but we are saying, high court, but they don't want to talk about anything. They don't want to deal with the case. We are in the dark. How are we supposed to proceed, Your Worship? How do we defend the rights of accused persons?
And so far as the statement refers to prejudice suffered by the accused person,
Yes, Your Worship.
I'll allow that line of
As the court
argument.
As the court pleases, Your Worship. And indeed, that was about as far as we're going to take it, Your Worship, that it causes prejudice. And this happens while we don't know the facts, the factual basis that informs these decisions. We're not aware. And we submit that in a constitutional democracy that respects human rights, the prosecution should act better than this. So in the final analysis, Your Worship, we ask the court to entertain this application. The grounds are there. This court has jurisdiction.
Thank you, Your Worship. First of all, Your Worship, I wish to point out that I believe the defense here misconceived our submission. We are not seeking for any postponement here. All that we are saying, we are submitting that based on the developments that are now present, namely that the accused person has now been indicted in the High Court. This court or his remand ends now, here and today. And therefore, this court, being a remanding court, will never do anything relating to this accused person in relation to these charges, 3 charges that have been indicted in the High Court. This is more so considering that, Your Worship, this court, in terms of Section 59 of the Subordinate Courts Act, as amended by Act number 6 of 1998, the sedition charge, that is count number 1 in the indictment, is only triable in the High Court, not here. My learned friend needs to revisit his law on this one. So, it will go together, therefore, with the additional counts in that charge, which is charge number 2 and 3. So, we acted within the law, within the bounds of the law. I was hoping and I was waiting patiently to hear this law he was referring to when he says, we have taken the counts that are triable here and left the one that is triable in the High Court here. That we refer this Honorable Court to the third section, that is section 59 of the Subordinates Courts Act as amended, that deals with the jurisdiction of this Honorable Court on criminal matters in respect of classes of offenses. Now, it is submitted that, or again, to take it further, now that the matter has been indicted in the High Court, in terms of section 119, that is 119 of Criminal Procedure and Evidence Act, this matter is now pending in the High Court. And I wish to quote the section, that is section 119, which reads, as soon as the indictment in any criminal case has been lodged with the registrar of the High Court, such case shall be deemed to be pending in that court. So, it shall be deemed. So it's mandatory, and this court therefore lacks further jurisdiction to deal with the accused person who has been indicted in the High Court in any matter inclusive of this one. And again, Your Worship, maybe to quote the section relating to the jurisdiction of this Honorable Court, says, that is section 59, as I earlier referred this Honorable Court to. The section reads, the court shall have jurisdiction over all offenses except treason, murder, and sedition. So, it takes sedition out of the equation from the jurisdiction of this Honorable Court. So, once this matter or the sedition charge has been referred to the right forum, which is the High Court, this court cannot further engage the accused in that matter. Hence, we are saying this court is now precluded from entertaining the application on release of this accused person. Now, it is submitted, Your Worship, that the indictment is meant to delay the application. Really? When we speed up the proceeding to go to the trial, then the argument says we are delayed. Really? Remember, Your Worship, the essence of the speed court trial is to rescue the accused person where there is delay in either prosecuting that person by charging him here at the magistrate court or indicting such person in the High Court. Now, when we perform our obligations under the law, we are being accused of delaying. Really, that argument, Your Worship, we submit is misconceived too. And we are fortified in our submission by the practice directive issued by the Chief Justice through circular number 3 of 2003, dated 18th December 2023. The circular reads, abuse of the law and court process in bail applications. Now, but for the purposes of my submission now, I wish to refer this honorable court to paragraph 2 of that circular, paragraph 2D thereof. C. Chief Justice says, the purpose of release from remand in custody served by the Speedy Court Trial Act 2002 is to regulate remand in custody where investigations stall. Now, here we are saying the investigations are complete. We are ready to take the matter to trial. So, the argument of the defense say, no, wait for me to apply to be released on Speedy Court Trial before you can go to the trial. Is that what we understand their argument to be saying? When they are saying the indictment is meant to delay their application. No, we are actually fast-tracking the process, actually. We are saying, let's go to the matter itself. We understand the accused person is in custody, hence we are saying, okay, let's proceed to the trial itself. Now we are being accused of maliciously delay. Now, what the defense will not tell this honorable court is that the prosecution informed the court as far back as the 26th August. It will reflect from the minute of the file, in the file, Your Worship, the minute of the 26th August 2025, that we were ready to take the matter to trial. But guess what the defense said? And they are not telling the court. No, we cannot go to the trial while we have the appeal pending in the High Court. That was their submission. They were saying, we do not have statement, and again, we cannot proceed to trial while our appeal challenging the remand itself still pending in High Court. Again, they will not tell the court that very appeal that they are using as shield of going to trial, that they are doing nothing to prosecute it to date. The defense, the applicant, is doing nothing, absolutely nothing. But at the end of the day, the Crown is being accused of delay, while he knows that he doesn't have clean hands. So, Your Worship, all that we have been doing, of course, we indicated as far back as 26 August 2025 that we are ready to go to trial on this matter, and we reiterated our position again on the 11th of September. Now, we are ready to proceed to the trial, urging either considering leaving the appeal so that we go to the trial, or we agreed to proceed. But what happened again on the 11th? Now, in the presence of my learned friend, Advocate Lusupi, they arose and said, no, we are applying for release on speed trial, not to go to the trial. That they will not tell the court. But they will only accuse the ground of delay maliciously. So, our submission, therefore, Your Worship, is that we simply had been trying to act in good faith, hoping that the accused person will prosecute his appeal, because we believe that appeal, since it was challenging the remand itself, saying he's being remanded unlawfully. So our understanding was that the outcome of that appeal will affect whether we are proceeding with the trial or not. Because if the ultimate finding of the higher court with the remand is that, oh, indeed, the remand was unlawful, it would mean everything is a nullity and he goes home and there is no need for anything further. So we gave him that opportunity to exercise his right. He made his choice to appeal. So while we are giving him that opportunity, now he comes back to accuse us of delaying. No, we have been ready. It's him who have delayed the process. But now, since we see he uses this, our acting in good faith, as I indicated, he uses it in a manner that we were not expecting. Hence, we are saying, okay, since there's nothing precluding us to proceed with the administrative work, then let's issue out the indictment that we have been withholding for a long time now. So we issued out the indictment to have the ball rolling. So there is no delay in anything here. As I have submitted that, actually the application of this nature comes where there is no action. Where there is no action. So when there is action, we are being accused of delay. So that's misconceived apprehension of the situation, my lady, of this situation. That now, to demonstrate that we are doing, my little friend suggests that we have just served them with the indictment, with the saving crime. We are not actually mandated to serve them with anything now. No. That is the communication between the offices of the magistrate and the registrar, since that is the administrative work between the offices. All that the accused person will get will be the notice of the trial that will be calling him to the High Court. Not this saving grant that is intended for administrative logistics between the offices involved. So our submission, Your Worship, is that from now, the accused person, his remands, he attending remands in relation to the charges as they appear in the indictment ceases today. He will never attend, he's supposed not to attend those remands further, since the matter is now pending in the High Court. So, and my friend submits that even if he is indicted in the High Court, this court can still proceed and deal with the release on speed trial as the remanding court. That argument also is misconceived, my lady, because I cannot foresee a situation where, whilst the High Court is proceeding with the matter of the inmates in the middle of the trial, one morning we wake up being told the magistrate down there has released you accused here. Really, that would be very upset. And it will likely bring uncertainty in the criminal justice, Your Worship. Hence, we are saying, by virtue of the provisions that we have referred this honorable court to, this court now lacks jurisdiction to entertain this matter for avoidance to make any adverse order that the High Court, where this matter is now pending, would otherwise not make. So that's our submission, Your Worship, and we submit that now that the matter should, this application is actually becoming moot. It's actually becoming moot. It has now been overtaken by the events. So we are not actually seeking any postponement. By operation of the law, this matter of accused attending remands before this honorable court is terminated by operation of the law, and that's it. That's our submission, Your Worship. My lady, I think your indulgence, Your Worship. My learned friend has hammered a lot on the issue of his statements here. And fortunately, Your Worship, we have also addressed it in our answering affidavits. However, for the record, her leadership will read from the record that we never undertook to give the defense statements on the 9th, as my learned friend suggests. No, the undertaking was just within 2 weeks. It was just said within 2 weeks. And we have clarified that. And it will appear from the record that, Your Worship, that undertaking came as the understanding was that, oh, we cannot proceed to the trial because we are not giving the statements, not knowing that actually the accused was also relying on the appeal. So we are saying, oh, okay, you are relying also on appeal. There is no point to give out the statements where there is likelihood of the appeal overturning the remand itself. In the event that that appeal is upheld, it would mean that whatever has been done is a nullity. And what will become of the witnesses that we have already given the applicant? Given the nature of the very danger that is inherent in criminal proceedings in relation to the witnesses. Hence, there is always in the bail applications, this condition: do not interfere with crown witnesses. because the cause, no, there is always this inherent danger as to the regarding the witnesses. So we cannot give, or we are not mandated, of course, in the protection of those witnesses to give out the statements where there is uncertainty as to the status of that trial. So hence I say, after he has prosecuted his appeal and now we all know the status or there is a certainty in relation to the trial, then we'll be ready to give out the statements. And to take it further, Your Worship, it's even difficult. We have been dealing with different counsel in relation to this accused person. We can't even give out statements to, we don't know who to give statements unless such time they know they have to write to us, to the office of the DPP, requesting the same, so that we will know, okay, so and so is representing the accused in the trial. Because for the counsel to represent an accused person in the bail application doesn't necessarily mean that counsel will, of necessity, represent the accused person in the main trial. So we have to be made aware of, to be assured by their request to our office that I am so and so representing the accused person in this trial, and therefore I'm requesting the witness statements in relation to this trial. They haven't done that, but still they accuse us of deliberately not giving them statements. But when that time comes, we will, and there is a certainty at the end of the day. So for the applicant to have that certainty in the trial, he knows what to do. He must prosecute his appeal to finality, the appeal which he conceals from this honorable court that he has lost and is the one that he is hiding behind not to get to the trial. So that's our submission, Your Worship.
A lot has been said regarding the genesis of this case, what has been going on from the moment the accused was remanded before this court until today. But before me now is an indictment by the DPP, and whether I have jurisdiction to entertain this application. As I said, I told you that I was on duty this week. I don't intend to go and sit down, go through this file and read what has been submitted. But from what I gather from you, I've already concluded that I'd have loved to say a lot, but I'm not going to. I don't know what to say. I don't know what to say to the prosecution. This is typically what we deal with, and it takes me back to a number of cases. I don't want to mention stuff that is not before me now, but it's really not pleasant to proceed on cases where you see people not really serious about proceeding. It's sad when you're a judicial officer and you have an accused person before you whose rights we have to take into consideration. The law is very clear. If we cannot proceed with an individual within a reasonable time, we have to admit them on bail. If that fails, we have the Speedy Court Trial Act that says after 60 days there are no exceptional circumstances that warrant his detention, then he should be released. And until now, I haven't had any exceptional reasons. I haven't had any one of the exceptional reasons why he should remain in custody. But now there's this indictment. And because there's an indictment that says he has to appear before the High Court. As soon as I was served, this comes to the attention of the clerk of court. They are right in saying that a week now, we can't do anything about it. So as of now, the only thing I can do is just to withdraw charges, not to withdraw, but to strike them off our roll, because now he's been indicted to the High Court. So that's as far as I can go. But it's what you are doing is not is not right. That's the least I can say. I could say a lot, but now you have everybody here. I wish you could go to chambers and then I'd tell you a lot of what I think about this thing. But as it is, charges have been struck off from the roll in respect of you, and what remains, as they say, on remand is the treason charge.
As the court wishes, and may he be remanded to the 25th.
And in respect of the treason charge, you would come to court on the 25th of November. The rest of the court.
As the court.
Good night.